My Lord, if I may, a few footnotes to the submissions before the adjournment. Firstly, to emphasise that one of the factors that your Lordships may wish to consider in choosing between discretion, presumption, narrow exceptions, discretion, presumption, broad, possible exceptions, no presumption at all, those are the three plates on the menu, is that one isn't only concerned here, of course, about certainty from the perspective of the Commission as the regulator. One is concerned about certainty from the point of view of the political parties. They will wish to know whether in circumstances where they are in receipt of donations from an impermissible donor, whether they can assume that they are going to have it forfeited or an equivalent sum forfeited unless, or whether it would be open to them to take their chance and put before a magistrate any factor that they conceive to be of relevance. And we would respectfully submit that the tighter that your Lordships draw the discretion, the more certainty there would be in the interest of all who are concerned in these matters. That's the first point. The second supplementary point is to bear in mind that this provision has to be seen in the context of a very elaborate scheme to prevent evasion of the rules against impermissible donations and their utilisation. Can I just give your Lordships at this juncture simply a list to illustrate what I have in mind? Your Lordships have not seen all these sections. I'm just asking to bear in mind that they are there as part of this complex and comprehensive scheme. There is section 24, 4 to 5, which imposes the responsibilities primarily on the Treasurer. There's section 31, which deals with notification of a party's officers, since, for example, were the Treasurer to die, the party leader it acquires his responsibilities. There is section 41, which deal with accounting records, section 42, which deals with accounts, and certain criminal sanctions for breach of those provisions in section 47. You've already seen the sections dealing with donations from sections 54 through to 58, but there are also obligations to provide quarterly donations reports in section 62. There are provisions dealing with control on loans in section 71, and there are other controls on campaign expenditure in section 72 and following. So section 58.2 is not some isolated island adrift in the sea. It's part of an archipelago of controls, and in our respectful submission, all designed to ensure that Parliament's purpose in avoiding the utilisation of impermissible donations is in fact backed by appropriate sanctions. The third point is to respond to the question pertinently raised, if I say so, by my Lord Walker about whether or not the fact that it appears that Mr. Bone admitted that he was not resident at the place where he appeared on the electoral roll was of any significance. It was not and could not be of significance in this particular case, since the application was for forfeiture in relation to donations made since that time. But there is actually, if your Lordships are interested, some evidence on the point in the part 2 of the appendix in section tab 3, where one of the witness statements that was available before the learned district judge was a witness statement of a Mr. Avis, who was the officer of the Thanet District Council responsible for maintaining the electoral register. You'll find that at page 199 of tab 3 of that particular bundle. And it's interesting, since it, as it were, provides more smoke than light. If you go to paragraph 6 across the page, Mr. Avis says that I have examined the electoral register for this period by searching the electronic records of the register. As a result of my examination, I'm able to state that Mr. Bone was not registered on the register at the Broadstairs address between the dates he mentions. I'm also able to state that he was registered on the register then at the same address from December 2003 until 1st December 2005, when his name was removed from the register of electors, resulting from the council tax department, presumably of Thanet, providing information to say that the property was void and empty, presumably with the consequence that they inferred that he was not resident there at the time. And then, a matter unexplored but on the record, Mr. Bone was not thereafter registered on the electoral register at this address until the 1st February 2006, following an application made. Now, was the property then, as it were, put into habitable condition and filled with furniture, or was it merely that because he chose to pay council tax, they assumed that that was sufficient? Did they apply their minds to the issue of residence? One simply does not know. That's all that one has. It's a peculiarity of this, but as I say, it's outside the scope of the inquiry in relation to the forfeiture in relation
It's rather inconsistent with the district judge's finding, isn't it, that there was some unfortunate mistake. And if one took...
Well, it depends what one means by mistake. I mean, there are two forms of possible mistake. One is a mistake in not registering someone who's applied to be registered. The other is a mistake in putting someone on the register who has no right to be there because he's not resident.
Right.
We're concerned. He was removed by mistake.
Yes.
What my Lord of Unsenate is saying is, it looks from this as if he wasn't. He was removed for the apparently thoroughly good reason that the address was vacant.
Yeah, yes, but...
I mean, the trouble is the district judge has held, having heard a lot of evidence, which we haven't seen, that Mr. Bone believed he'd signed some forms to continue it on the register. Heaven knows what they said and which address they gave. And that the district judge was satisfied that his not being on the register was a genuine inadvertent error by someone, him, the Postal Service, or the Thanet District Council.
And moreover, the parties have agreed that in the statement of facts.
No, absolutely. But
still, I dare say if it was ever remitted, Mr. Beloff, all these matters could be considered.
Your Lordship is too enthusiastic for that particular point. One does bear in mind that Mr. Bone himself, in his witness statement, did say that he signed a form to continue on the electoral register. So there is, in a sense, a tension. Was he removed by accident? Was he removed properly but not reinstated by accident? It sounds, if one wished to reconcile the two, it's a second of those hypotheses. But
actually, if it went back, just as a matter of interest, it would presumably go back, wouldn't it, on the basis of the present findings of fact? One wouldn't...
I mean, it's inconceivable that your Lordships, after all, it's had 3 days. For better or for worse, each party put their best case forward. It could not conceivably be proper to remit it for a further review of other matters. But I'm going to come to that at the end, if I may. One more point before we get to what's, in a sense, the shorter point of construction, the all or nothing, the so-called bias point, which achieves at any rate this distinction. I suspect it's the first and will probably be the last time that there's been a reference made in a party's printed case to this court to Wikipedia, not usually regarded as a journal of authentic record. The point, as I understand it, and I can deal with this very summarily, it was a subset of the confidence point, and it was said to feed into why this court should hold that there was the maximum discretion to the magistrate or sheriff to counterbalance any perceived bias on behalf of the Electoral Commission. There were two strands to this. The first was as to the composition of the Electoral Commission. Your Lordships will recollect it comes in sections 2 and 3 of the Act, in which it is said that the major political parties have some influence where there's no equivalent locus standi given to the minor parties. Our response to that is a matter of legislative choice, and it is perfectly reasonable for Parliament to draft it in that way, in the same way, for example, as your Lordships will be well aware, the obligations on the British Broadcasting Corporation to allocate time for party political broadcasts are not done on the basis that every party is entitled to the same time. They are done to reflect, in a sense, what is thought to be appropriate. There's no unfairness there because there is, as it were, absence of parity. So that point simply is irrelevant. The second point, as we understood it, is that there may be a perception, because any suggestion that the perception recognised reality was discounted, of disparate treatment by the Commission between the parties in engaging the forfeiture machinery. As it were, Bown against Brown for the Liberal Democrats was given as a paradigm example. My learned friend might have mentioned, it's a matter which your lordships can take judicial notice, that Lord Ashcroft and his company Bearwood Securities were equally determined that by the Commission not to be in breach of the legislation. But as my Lord Simon Brown pointed out at an early stage, in both those cases, the Liberal Democrat case and the Conservative case, the Commission came to the conclusion, on thorough investigation of the material, your lordships have no material before you about that, but you could make a presumption of regularity, that there was simply no breach of Section 54, and so the question of remedy was never reached. And candid, what my learned friend's submission came down to when one analysed it was this: if one were a conspiracy theorist who was ignorant of the true facts of the matter, one might suspect the Electoral Commission of favouring the big battalions. In our submission, that does not illuminate the problem that your lordships face as to construction, if, and this is entirely hypothetical, if there was any evidence in the future that some commission discriminated between the parties, let us say, determined not to engage the forfeiture application in respect of the Liberal Democrats or the Conservatives, even though they were in receipt of impermissible donations, because they did not wish to get across, to use the colloquialism, the powers that be, and if there were evidence to that effect, they would be amenable to judicial review. It's, of course, an entirely false, implausible hypothesis, but now submission no more implausible than the argument that my learned friend sought to advance in this new bias point. And the reason that I refrained from objecting to him taking the point at all, that I did not see any advantage in interrupting him in a point that had no substance in itself. And can I then come to the all or nothing issue, the second major point of construction, which is dealt with in our printed case between paragraphs 22 and 45. It was, as your lordships will know, a point rejected by Mr. Justice Walker at paragraph 117 and was abandoned before the Court of Appeal, and there's been what our submission a vain effort to resurrect it. And this is a pure point of construction, what is meant by forfeiting a sum of an amount equal to the value of the donation. And our points are very short. Firstly, the language is clear. The forfeiture order must be for an amount equal to the value of the donation and not to any lesser or greater sum. Mr. Justice Walker was entirely correct when he analysed Section 58.2 as having two limbs and raising two questions. Firstly, should there be forfeiture at all, in which he came to a particular view on discretion, but secondly, if there is to be forfeiture, of how much, in which he recognised that there was no flexibility. And if I may be forgiven for simply quoting from what he said at paragraph 117, your lordships will have read it, it's at tab 5 at page 238, it is not possible to read section 58.2 in the way UKIP suggests, that's to say, as if it read up to, or no more than, or indeed for that matter, no less than, which is Lord Neil's preferred approach. The Court of Appeal also held quite correctly that Parliament, looking at it in the other perspective, actually did not expressly provide that the order for forfeiture could be made for less than the value of the donation, which would be another way of dealing with the matter. And they, at paragraph 49, gave a reason why Parliament made that choice. What Parliament wanted was a clear and readily enforceable system, which would have as its purpose and target that all donations that were utilised should come from permissible donors and not from impermissible donors.
Sorry, 49 in the Court of Appeal?
49 in the Court of Appeal, tab 5202. So that's the linguistic point. The second point is that the legislative history is quite inconsistent with UKIP's construction, because even putting aside the language actually used, the contrast between what was proposed at one stage by the Neil Committee and the choice that Parliament made is, in our respectful submission, instructive. Your Lordships have heard several times and scrutinised several times the relevant paragraphs, both in the Neil Committee and in the White Paper. The relevant paragraphs are 5.42 in Neil and 4.15 in the White Paper, and they rejected a more flexible system that might or might not have had its adherents in favour of a simple system which set the level of forfeiture at the amount of the donation. What does my learned friend then juxtapose to that? Firstly, he says the principle against doubtful penalisation. That's a principle well embedded in the common law, that one doesn't expropriate persons or take their property or interfere with their rights without clear language. That doesn't, in our respectful submission, provide any assistance here where the language as to quantum is entirely clear. He also relies upon the so-called principle that the greater includes the lesser. When one looks at the authorities that Mr. Benyon, Professor Benyon, cites in favour to support that proposition, one sees that they are entirely out with the legislation of this kind. They are dealing with matters, in particular in the criminal sphere, where a charge of a greater offence is deemed to include the lesser offence as well, for obvious reasons. It simply cannot work where the legislative language says sum equal to, because a sum equal to is, as it were, fixed there. There's no possibility of reading it down because the greater includes the lesser. He then says, well, if Parliament says no forfeiture at all is a possibility, or it says there's going to be forfeiture of an amount equal to the value, ergo, it must follow that Parliament has envisaged the possibility of forfeiting something in between. It's simply, with respect, a non sequitur. They might have provided that, but they clearly didn't. And then the new argument, I think, but bearing on something that was advanced by my Lord Clerk, was, well, if there are a number of donations, why should a court not decide that they will forfeit some but not others of them with some kind of totality principle, as one finds in the criminal court? And the short answer to that is that that could not be a proper exercise of a discretionary power, however one construed it in terms of quantum, because there would be no rational basis for distinguishing. Let us take the chart I've given you in Mr. Bones' forfeited, or the donations we seek to have forfeited, between any of the particular sums given. In the case of any one of them, the case for and against forfeiture is identical. So that, with respect, cannot be a reasoned solution to what's perceived as being a problem, but only if one wishes to undermine a clear legislative choice, which my learned friend then seeks to do by referring to Section 3 of the Human Rights Act of 1998 and Article 1 of the First Protocol. Now, in our printed case, we have analysed under which of the headings of the interference with the peaceful enjoyment of possessions this forfeiture regime is properly located. And we would respectfully submit that the better view is a view, and I'm not, again, conscious of the time I'm going to take your lordships to the cases, the better view is that in the encyclopedic work of Mr. Clayton and Mr. Tomlinson of Queen's Counsel at paragraphs 18140 to 18142, for your Lordship's note, the third authorities bundle at tab 49, where they aggregate, in our respectful submission, all the cases on forfeiture, penalties, confiscation orders in support of statutory regimes as being within the second rather than the first paragraph of Article 1 of the first protocol. And we say that's the correct analysis and supported by cases like Agosi, the Krugerrands case, and Gassos dossier, the tax case. But the reason I don't dwell on this is it does not matter. Just assume, for the purposes of argument, that this is a deprivation case within the first paragraph of Article 1 of the first protocol. We respectfully submit that there, in that more extreme interference with the right to peaceful enjoyment of possessions, Strasbourg has made it clear that there is a considerable margin of appreciation to be accorded to a legislative choice, in particular in an area where the legislation impacts upon social, economic, or, as my learned friend conceded by reference to the observation of Lord Justice Laws in the SRM case, political issues. Can I just show your Lordships one authority just to make good that proposition, the James case, which is in the first bundle of authorities at tab 5, which was the case in which the Duke of Westminster failed to, in his assault on the leasehold enfranchisement legislation. And the point I want to make, so that your Lordship knows where this submission is directed, is that both at the juncture where the Strasbourg court were considering whether or not leasehold enfranchisement was justifiable at all, and at the point where they were saying, if it is it right that compensation should be lower than at market rate? At both junctures, the phrase, which is constantly repeated in the jurisprudence since that time, of without reasonable foundation, is utilised. If you go there, just two paragraphs, 46 and 54. 46 is at page 142 of the report at tab 5, and the rubric is whether the leasehold reform legislation complied with the public interest test and the remaining requirements of the deprivation rule. And then they deal with margin of appreciation, of course, saying we're an international court policing a domestic decision, but as I show to your Lordship, it feeds in to our domestic approach. And what you see at the foot of the page is 5 lines in the end. The court finding it natural, the margin of appreciation available to the legislature implementing social and economic policy should be a wide one, will respect the legislative judgment as to what is in the public interest unless that judgment be manifestly without reasonable foundation. Very strong language indeed. And then when one looks at when the issues came as to whether or not the means chosen and the limits to compensation were vulnerable, again one sees at 54, page 147, last paragraph, the court further accepts the Commission's conclusion as the standard of compensation, the taking of property without payment of an amount reasonably related to its value would normally constitute a disproportionate interference which could not be considered justifiable under Article 1. Article 1 does not, however, guarantee a right to full compensation in all circumstances. Legitimate objectives of public interest, such as pursued in measures of economic reform or measures designed to achieve greater social justice, will call for less than reimbursement of the full market value. Furthermore, the court's power of review is limited to ascertaining whether the choice of compensation terms falls outside the state's wide margin of appreciation in this domain, and then there is a cross-reference again to paragraph 46, so one sees that the test of manifestly without reasonable foundation is again applied there. And if that's how the Strasbourg court approaches a question of challenge under Article 1 of the first protocol to a out-and-out deprivation case, it's a fortiori with some lesser form of interference. Now, how does this feed into domestic court? Well, there are two routes. One is the one ingeniously advanced by Lord Justice Laws in the Northern Rock, the SRM case, which is to say, if we are to apply Strasbourg jurisprudence as we are to in the domestic courts, this includes the margin of appreciation. That's, as it were, a direct route. The indirect route, the one perhaps more conventionally applied by this court and the House of Lords, is Lord Hope's well-known speech in Ex parte Kebeli, which I don't need to cite to this court, where he said the domestic analogue to margin of appreciation in Strasbourg is the wide margin of discretion accorded to, in particular legislation, and in particular legislation in spheres that are peculiarly within the province of the legislature, of which one might instance regulation of the political process as being prime. On either of those two ways, we respectfully submit that the test is the test of devoid of reasonable foundation. And here, in our respectful submission, it cannot be said that it is devoid of reasonable foundation to require someone to disgorge a sum equivalent to that which the legislature, for good and sufficient reason, has decided that they should not have enjoyed in the first place. Of course, one can envisage a range of possible solutions that Parliament might have chosen, but that is simply immaterial. One might note that Lord Neil chose a different route, a somewhat, in one sense, more stringent route. That simply points to the fact that there are a variety of solutions that could have been chosen. This was the one that was chosen. The language is nicely calibrated, and in our respectful submission, it is impossible to say that the Strasbourg test or the Kibbeline test is satisfied. In any event, as my learned friend anticipated, we say that to the extent that one is looking to the principle of proportionality here in the alternative, the fact that the sum is no more than the value of the impermissible donation, in our respectful submission, itself reflects a principle of proportionality, exactly as Lord Bingham in the criminal confiscation case in the passages that I referred your lordships to before the adjournment did. It is exactly what one would expect the position to be. My learned friend gets no purchase at all from the cases so carefully analysed in the appendix to his printed case about forfeiture and confiscation of vehicles which have been used advertently or inadvertently for smuggling of goods into the country, because in those cases one starts from the proposition that the cars were properly theirs and there was nothing wrong about their ownership of the cars, that the goods that were forfeited vastly exceeded the duty that was payable on the smuggled goods, and there are a variety of other distinguishing features. So, in our respectful submission, one has to look at this case in its own context and in its own merits. And as the Court of Appeal noted, perhaps one may just look at what they said at paragraph 42, as it were, this is a plea, as it were, to the apparent injustice of the legislative regime. What they said, if your lordship be good enough just to go back to that for the last time, at paragraph 42 of their judgment, is this. The Act, they said, is carefully structured to avoid injustice. The donor has chosen to make a gift, so he cannot expect to be returned. The party has 30 days to check that the donor is a permissible donor, and if after that period an order is made for it to forfeit to the state an amount equal to the value of the donation, that is only ensuring it does not have the benefit of a donation it should never have retained. The only loser would be the donor whose donation will not be used as he intended, but he can be protected by the party doing as the Act requires. In addition, he can protect himself by ensuring he is a permissible donor. I mean, incidentally, Mr. Bowen's donation has in fact been utilised. The party, unfortunately, if the forfeiture order were to be in place, would have to give an equivalent sum, not the same sum, but that's only, as it were, a minor qualification to what is there said. But at 45, the last 3 lines, 5 lines, unless the normal consequence of an impermissible donation, this is where he deals both with the presumption and the quantum issue, brought to the attention of the court is an order for forfeiture of an amount equivalent to the value of the donation, parties are in reality free to disregard the provisions of section 54 and 6 with impunity, and I struggle to see how such an order can be described as disproportionate when by statute it is restricted to the value of the donation, a donation which should never have been accepted if the party had done what the law requires. In our submission, that puts that, if I may respectfully say so, better than I am able to, and we would respectfully rely upon it. Now, I come lastly, if I may, to the irrationality issue, and I do remind your lordships that my learned friend takes objection to this point being raised. We deal with this in the printed case at paragraph 84 and following. Now, it is with respect very important to note that the argument that we advanced to the Court of Appeal was an argument with 2 separate limbs to it. One was what I've called the presumption point, and the other was assume we're wrong about that. On any view, the facts of this case compel the conclusion that the rational and only rational order is the order to forfeit. I think I should show your lordships that, because it with great respect, makes unsustainable the suggestion that when Sir Paul Kennedy used the language of irrationality, he wasn't reflecting the argument that we advanced in this alternative way. If I can just take your lordships to part 2 of the appendix at tab 13 and then at tab 16, firstly looking at our grounds of appeal and then at our skeleton argument. Is this here?
You're taking us to part 2, tab what?
13 in the first.
1, 3.
Thank you very much. If I could just show you first the grounds of appeal, which is at tab 13. And if we look firstly at subparagraph 4 at page 914, you will see the learned judge ought to have held the magistrate should have ordered the forfeiture of all the impermissible donations because there were no exceptional circumstances or circumstances which justified not ordering forfeiture in this case. So that's the presumption argument. And then if you look at 12 and 13, 12 says the learned judge ought to have held the magistrate's refusal to order forfeiture of the impermissible donations was irrational. And then we set out a series of reasons, and we point out that Mr. Justice Walker found it difficult to understand how, at any rate, in respect to part of them, he could have come to any other conclusion, even though he wasn't prepared to say that his imagination was deficient. If one looks then at our skeleton argument, which is at tab 16 of the same bundle, we can make with respect exactly the same point.
Tab what?
It's not. If you go to paragraph 19 in the first instance.
Sorry, tab.
This is tab 16 of the same bundle.
Skeleton argument on behalf of UKIP.
No, this is.
It's the same thing, but behind it.
What? It's with the two. Both skeletons are in the same tab. Ours is at the back. They haven't been divided. They no doubt should have been.
So what page is it?
If you look at 1001. Saying what the central issue was, and above that is the submission that is being then adumbrated. Impermissible donation should be ordered to be forfeited in the absence of exceptional circumstances. So that's what we were then engaged in at that particular juncture. And then, if one goes to 40 at 1011, the point is made crystal clear The magistrate did not find on the facts, nor could he properly find there were any exceptional circumstances, other circumstances justified a order forfeiture. Therefore, on the basis of true construction, he ought to have held the magistrate should have ordered forfeiture of all the permissible donations. Then at 41, if the primary case of the Commission, that on the true construction of Section 58.2, the magistrate ought to have ordered the forfeiture of the impermissible donations in the absence of exceptional circumstances, is not accepted in any event. So this is the alternative argument. It is submitted the learned judge's approach, the magistrate's exercise of discretion, was flawed for the reasons set out below. And then we set out a whole series of reasons coming up to a further conclusion at paragraph 54, 1024 of that bundle. The magistrate's refusal to order forfeiture of the impermissible donations was irrational.
Of course, these do depend, though, on the content of these various points, like the non-foreign status, irrelevant point. So if that were rejected, then what?
Well, no, with great respect, we made it absolutely clear that there were at least two separate lines of attack. And the second line of attack assumes that the learned judge is against us on the presumption point. If he's against us on the presumption point, he's then in the area which my learned friend says is the proper location, i.e. it is a general discretion.
I follow that, but you're under that general point in paragraph 41, you have section A, and section A is donors non-foreign status or entitled to be on electoral register, irrelevant.
Yes.
So that isn't a discretion point, that's a point of principle. Now, if that point were rejected, you won that point in the Court of Appeal, but if it were rejected, then what?
Well, but, my Lord, if you go to 54 and following, you will see what I call purged of any suggestion of legally irrelevant or otherwise. These are the facts, and there is only one rational conclusion.
Well, except you do say 54, having regard to the legally relevant considerations and disregarding the legally irrelevant identified above. So it's all conditioned on your view of what is relevant and irrelevant.
Yeah, but any, as it were, attack on that basis has to be premised on a correct self-direction. But all we're saying is, with great respect, is here you have the Court of Appeal quite clearly using, in the last paragraph, the vocabulary of irrational, of irrationality. You have a highly experienced, if I may say so without any offence, a public law judge using language that only means something to persons in that, as it were, last category. It's Wednesbury unreasonable. That's what he was saying. He isn't saying, for example, I find in your favour on the presumption there's nothing to displace it, full stop. He deals with both points. He's accepted both our arguments at this particular juncture. And that's why we say we find with great respect a forensic gamble, but it might be said to be bizarre, of my learned friend to say the onus is on us to establish that this point is properly arguable before your lordships. On the contrary, the onus was always on my learned friend to say the Court of Appeal were wrong to say that there was only one rational conclusion on all the facts. And do bear in mind for this purpose that the Court of Appeal went at some length into the facts. They went into the facts as found, and they went into the additional facts as one sees. At paragraph 9, the SDJ made no reference, the undisputed history of relations, etc. There was a great deal that the learned district judge did not refer to because of the somewhat blinkered approach he took to the issue of section 58, subsection 2. But the statement of facts which has now been agreed reflects what it is that was either expressly found or in evidence and not disputed. That's the purpose.
I'm sorry, Mr. Belloff, I don't quite see why. If you're right, why on earth was the Court of Appeal remitting the matter for reconsideration?
But it's the Padfield mandamus, isn't it? Usually one says, reconsider in the light of the ruling of the court, which in most cases, will be a ruling of law, or including on this construction, or a ruling of taking into account this factor you didn't. But it equally is conceptually possible to say, we've looked at all these facts, there's only one conclusion, we're going to remit it to you because you are the body that has to take the decision.
But in a case stated and things like that in the divisional court, you remit to the magistrate to convict. And if in fact here you're saying we have to read the Court of Appeal judgment as we're remitting it for the pure formality of you to forfeit because you would be acting irrationally to do otherwise, they would have said that. They haven't done that at all. They've said for reconsideration.
No, with great respect, the reconsideration is of the matter before them in the light of, assume the case hadn't come before your lordships, in the light of what we have said, there's only one rational decision. It's respect that is paid to the statutory framework that the decision maker must be the magistrate, but the magistrate can only decide in accordance with the law, using that in its broadest sense, and in particular with a ruling of the Supreme Court saying, looking at all these facts, as indeed the Court of Appeal looked at all these facts, there is only one conclusion.
It's rather bizarre that he says the last sentence, then, whether the matter's dealt with by the senior district judge or someone else seems to be something which can be left to the magistrate's court to decide. That seems to suggest that he thought that there was something to be decided, which is...
Well, but how would that be consistent? I'm not asking it just rhetorically. I mean, if there is only one rational view, an appellate court says, on what were an extreme facts of this case, that's what is meant.
No, I see that.
And I suspect the argument is, don't send it back possibly to the district judge himself, who's expressed himself quite strongly. It might be a cause of some embarrassment to him. There might even be the possibility of a tension between. He might say, I'm just not prepared to accept this. Who knows? All this is a deference paid to the judge at first instance. Now, because this really is the last point I want to make, can I just simply, by reference to the facts, and I'm just going to recite them and give your lordships the reference to them, why they came to that conclusion. And there are, I think I have 13 points. First is, and I'll give you the reference to each, UKIP admitted before the magistrate that it had not taken all reasonable steps to verify that Mr. Brown was a permissible donor, which was contrary to its duty under Section 56(1) of the Act. That is specifically referred to in the district judge's judgment at paragraph 15. Most of the rest of the facts were not referred to, and the references will accordingly be to the statement of agreed facts. Second, in 2001, UKIP accepted a donation of £50,000 from Sir Jack Hayward when he was not on the electoral register. In other words, not being too disrespectful, UKIP had a certain amount of form here. In any event, they were certainly alert to what their obligations. That's SFI, Statement of Facts, paragraph 6. 3. This led UKIP to add to its internal donation report a request for the electoral registration address of any individual donor. Perfectly sensible. But this request was removed from the report form by Mr. Smith between May 2004 and May 2006 in order to simplify the form. That's the Statement of Facts at 9. So, I mean, in a sense, authors of their own misfortune, but by quite deliberate choice, inconsistent with their duties. Fourthly, on the 14th of April 2005, 4.5 months after Mr. Bone ceased to be a registered elector, the Commission by email asked the then Treasurer of UKIP to explain donations, apparently from Mr. Bone, but attributed to 2 separate addresses. That's at the Statement of Facts at 10. There was no reply to that email, despite a reminder sent on the 13th of May 2005, same paragraph, again, one would with respect say, entirely heedless of their obligations to respond to questions of that kind from the statutory regulator. Sixthly, the flow of donations from Mr. Bone to UKIP continued, and so on the 24th of June, the Commission sent another email to UKIP raising questions about the donations. Again, statement of facts at 10. Again, there was no response, and the flow of donations from Mr. Bone to UKIP continued. So every time one has, as it were, a coincidence, a pattern, a whole series of donations coming, on each occasion an obligation to check whether he's on the electoral register, total failure to do so, and total failure to respond to the legitimate inquiries of a concerned commission. That then led, 8, to a letter dated the 5th of October 2005 from the Commission to UKIP, asking the party to check the names and addresses of donors, including Mr. Bone, and to provide correct details for each, same paragraph of the Statement of Facts at 10. Fact 9, on the 18th of October 2005, the Commission contacted the local authority which had maintained the electoral roll where Mr. Bone had been previously registered and established that he had not been on the electoral register since 2004. That's the next Statement of Facts at paragraph 11. On the 24th of October, just over a week later, the Commission passed that information to the then Treasurer of UKIP, who promised an email with Mr. Bone's registered address, same paragraph, Statement of Fact 11. 11th fact, on the 28th of October, in response to a further telephone call from the Commission, so they're still pressing, still getting no response, what we then get is the Treasurer of UKIP said he'd not been able to obtain the address at which Mr. Bone was recorded on the electoral register, but he did believe Mr. Bone had been on the register when the donations had been made. Belief. That's a Statement of Facts 11. 12. UKIP continued to assert that Mr. Bone was registered as an elector until a meeting with the Commission on the 13th of December of 2005. So that, again, that's in the Statement of Facts at 11. So again, even though they had no basis at all from the official sources, they were being chased by the Commission, they were still in receipt of a flow of individual donations when they chose not to check. And they then were actually saying, contrary to the true facts, that he was registered. The 13th, the then Treasurer of UKIP said he did not personally check the electoral register, but relied on others at the local level, knowing whether or not donors were registered. That's SFI 11. That's, if I respectfully say so, as feeble an excuse for non-compliance with the legislative regime as one can envisage. And we respectfully submit that in view of those undisputed facts, the Court of Appeal detected nothing which would entitle a magistrate's court not to make a forfeiture order of all the admissible donations made to UKIP and concluded the magistrate's refusal to make such a forfeiture order in these circumstances was irrational. And we do note that the administrative court, while not accepting that argument, after referring to UKIP's failure to check on Mr. Bone's status despite repeated queries by the Commission, Mr. Justice Walker, at paragraph 93 of his judgment, said, "It is difficult to envisage how the senior district judge could reasonably have concluded, at least as regards donations in the period leading up to the awareness date, that forfeiture was not warranted."
Paragraph what?
Paragraph 93. Difficult to envisage, we would respectfully submit, impossible to envisage how he could reasonably have come to that particular conclusion. And we respectfully suggest that this is as clear a case of non-compliance as one can envisage, that whatever Mr. Bone's actual status or responsibility for the absence of being registered matters not. The obligations are deliberately imposed on the party. The party were heedless of those obligations. They took no account of legitimate inquiries by the Commission. They simply continued to reap the harvest of this prohibited fruit. That's precisely why one says with great respect that those considerations by themselves, even putting into account the fact that Mr. Bone could have been registered, even putting into account the fact that wherever he may or may not live, one wouldn't colloquially describe him as foreign, even putting into account the fact that UKIP is a small party, though by no means the smallest of the registered parties, even taking account of the fact that they have a small amount of staff, that cannot, in our respectful submission, and the Court of Appeal were quite right to hold, it simply couldn't outweigh these other factors. A treasurer has responsibility, and if you want the benefits of registration, you must accept the burdens as well. Now, that being so, there having been 3 days of hearings, the Commission arguing in the alternative their major point of construction that the facts simply spoke with one voice to one conclusion, the Court of Appeal having endorsed that conclusion, in our respectful submission, whatever your lordships were to decide about the points of construction, your lordships would have to say that unless my learned friend can persuade your lordships that the Court of Appeal were wrong to attach the statement of irrationality to the decision of the learned district judge, what the Commission are bound to, as it were, succeed or maintain their success in this appeal. My learned friend has chosen, as I say, not to address the facts in opening. He's given your lordships the reasons. We say with respect they were wrong. I make no objection to him seeking to address them now. I mean, the facts are the facts, and I've set them out there, and your lordship knows what other facts there are. There are no other facts to be found. All that remains is for a district judge properly directed by this court, both as to law and in respect of the Court of Appeal's finding as to the facts, unless they choose to divert from it for whatever reason, is to go back to it and bring this particular matter to the end. Let it be a lesson to all other parties that this regime is seriously intended, and that the Commission's actions in relation to the receipt of these impermissible donations was entirely proper, given their important responsibilities. Unless I can assist your lordships further, those are my arguments on all what we concede to be the relevant points.
Can I just ask one point?
Yes,
suppose we were against you on that point and thought that the outcome wasn't inevitable. Does it follow from the fact that there was no appeal against Mr. Justice Walker's decision that it should be remitted for lack of reasons, that we would be obliged to send it back to the district judge? Or would you say, since all the facts are before us, actually...
I would say all the facts are before. I mean, your lordships have a certain choice. I mean, assuming that I'm right that this is an issue that was before the Court of Appeal, decided by the Court of Appeal, and therefore open to debate before your lordships. You could decide that the Court of Appeal took too stringent a view of the facts, because there are other facts that my learned friend might wish to refer to, also the statement of agreed facts, that would mean that there were possible other outcomes, in which case it would go back to the district judge, not to rehear, but to re-look, as it were, the matter. Or your lordships might give him what I might call a steer, saying it looks to us there's a certain degree of difficulty in UKIP's position, or your lordships might say, well, actually, looking at it, there are things to be said on both sides, and you decide which way you want it to go. I mean, there are a variety of possibilities. What I don't think, with respect, would be open or desirable is to ask for the matter to be reheard. Why should it be heard again? Both sides have put their best case forward, for better or for worse. The facts are all in the record. The fact that the learned district judge didn't choose to absorb some of his judgment is neither here nor there. What is inevitable is that your lordships are going to say, whatever your view as to the point of construction, giving guidance on what would be relevant considerations, whether to displace a presumption or just generally. And that would be a guidance not only to whoever it were remitted to, but to courts in the future. What we don't say is that this is inadequately reasoned. That seems to us, with respect, to be undesirable, and really this matter ought to be brought one way or another to an end. Anything further?
Thank you very much. Mr. Dillon.
Nothing further to add, Mr. Bell.
Thank you. Yes, Mr. Long.
My Lords, can I deal first in reply with the last section of my learned friend's submissions on what he calls the irrationality point. With great respect to him, I submit that he has fundamentally misread the relevant paragraph of the Court of Appeal's decision. Could we just look, please, once again at the text of paragraph 50, which is in tab 5 in the core volume, page 203. The paragraph starts, what then is the scope of the discretion granted by section 58(2). Properly considered in the context of this statute, it seems to me to be narrow. And Sir Paul Kennedy then goes on in the next 8 lines or so to define the width of the discretion, as we all know. And that takes one down to the words more than once in the 8th line. Then one sees this, but in the present case, I can detect nothing which would entitle the Magistrates' Court not to make the forfeiture order which the Commission seeks. Reverting to the grounds on which judicial review was sought, I am satisfied that the District Judge erred in his construction of the Act. His refusal to order forfeiture of an amount equal to the value of each of the donations was not a valid exercise of the discretion under section 58(2), i.e. the discretion as held by the Court of Appeal in the previous 10 lines or so. And as Mr. Justice Walker found, his reasons were inadequate. In other words, i.e. reverting back to the previous sentence, in other words, the decision was irrational. It was irrational because on the basis of the Court of Appeal's decision as to the width of the discretion, there was no alternative, so said Sir Paul Kennedy, but to forfeit. And one can see that
another way of expressing that is to say that the finding of irrationality was based on the premise that the wrong discretion was exercised.
Exactly.
And we are invited by Mr. Beloff to consider it on a completely different basis.
Exactly.
Namely, as if the construction that you advance is correct.
Exactly. Exactly so, with great respect. And really what my learned friend would need is a further paragraph in this judgment, which started, what if we are wrong about the width of the discretion? What if non-foreignness of donor, size of party, etc., were all factors that were potentially relevant? Pause there, even weighing up those factors, taking into account the various facts in the case, we consider that it would be irrational to take any course other than to forfeit. That's what he needs if he's to even get his present submission off the ground, and it's not there. He hasn't got that finding from the Court of Appeal. It follows, and I think this is conceded, that he does not have permission to take the irrationality point, and the point, with respect, stops there. If I am wrong about that, I have a second procedural objection to the irrationality point, and that is this. The question of the correct construction of Section 58 is presently in limbo. We, on our side of the case, very much hope that the Court of Appeal's construction is not going to be accepted by this court, but we don't know, none of the parties know, precisely how this court will define the discretion if this court decides to overturn the Court of Appeal's judgment. It is only once this court has carried out that exercise and defined the law in this area that properly informed submissions can be made as to the application of the law to the facts of this case. And so, if one wanted to be formalistic about it on Article 6 grounds, if nothing else. It would be, in my respectful submission, quite inappropriate for this court at this stage, having not heard informed submissions in that way, to make any sort of determination on the facts, as my learned friend seeks to persuade it to do. Lords, I have those two procedural objections. If neither of those two objections were made good, then I would certainly want to respond, more or less point by point, to the submissions that my learned friend has placed before you on the facts. That's an unattractive exercise in terms of timing and otherwise, but it will be necessary. Can I just leave my procedural objections there, complete my reply on the other points that call for a reply, and then conclude my submissions by making some observations about the facts of the case?
Could I just ask you this? Supposing that suppose this court upheld the reasoning of the Court of Appeal throughout.
Yes.
What, if any, point is there then in a remission?
Almost none, my lord, because on the basis...
You'd be bound to lose.
We'd be bound to lose, as I see it, yes. On the basis of the Court of Appeal's reasoning, if the district judge loyally applied that reasoning, I think I have to accept that we would be more or less bound to lose, yes.
Can I just ask where, without going ahead to the facts now, but the district judge's judgment was held to be inadequate or thought to be inadequately reasoned, certainly by the judge. You've referred to culpability. We can probably form a view on that. There's also been reference to effects, impact. I'm not sure where the evidence is of that. I mean, was there evidence about that before the judge?
There was evidence before the district judge that the funds available to UKIP at that time were very modest.
I see.
£5,000 or £10,000 or so.
Yes, I see. So, although he doesn't refer, I think.
He doesn't refer to that, but it would flow from that, as we discussed yesterday, that the consequences of a large forfeiture order would be very severe.
Yeah. He must have had it in mind. Or...
He might have done, my lord, yes. Just before moving on, and considering the question or the possibility of remission, I agree with my learned friend that it would be very undesirable for the case to go back for a further full-blown fight with 4 or 5 witnesses being cross-examined before the district judge on a second occasion. The hearing below lasted at least 3 days and was a dogfight of the usual sort. And it would be quite wrong for that process to take place again. But if this court does decide that the matter has to be remitted, then what the courts, or the court and the parties are faced with, is a situation in which the district judge did provide a relatively short judgment. My learned friend has said that it was a cursory judgment. We think it was a good judgment, but it was certainly a relatively short judgment. And it doesn't deal with all the facts that would, as we see it, potentially be relevant to the exercise of the court's discretion. So as we see it, if it has to go back to the court below, then it should be on the basis that there should be, absent some exceptional circumstance which the court below could consider, there should be no further cross-examination of witnesses, but the court below should re-exercise its discretion in the light of this court's ruling as to the construction of the section. By reference to the evidence that was given below and the documents in the case, and by reference to the submissions that Mr. Belloff and myself or other counsel will place before the court. That we would respectfully submit is the only fair way in which the matter can be dealt with if it has to be remitted. We, of course, would much rather that it were not remitted and that this court would take the merciful view, having reversed the errors made by the Court of Appeal, that UKIP, having been brought all this way and no doubt incurred significant irrecoverable costs, and also been deprived of donations in recent times, because I'm instructed donors are simply not prepared to give money to a party which is potentially in substantial debt to the state. For all those reasons, a merciful course would be to say, enough is enough. The Commission has finally managed to define the law. UKIP has been sufficiently warned off, and the matter should end here. That, of course, is the indulgent outcome, but we would say a fair outcome that we would most like to see. If it does have to go back, it should be on the basis that I have outlined. Leaving then any detailed submissions on the facts for the moment, can I take up 3 or 4 points in reply to my learned friends' submissions on the main issues of law? First, a short submission on the width of the discretion. We obviously, until this morning, had not seen the 2007 guidelines, internal guidelines that the Commission uses in this area. I submitted yesterday, on the basis of a pretty tenuous inference that I drew from what was said to the district judge, that the Commission did regard itself as having a wide discretion. And it turns out that that submission, fortunately, was well-founded. The Commission, we can see from the guidelines, the Commission plainly thinks, rightly, that somebody must be able to exercise a flexible and wide discretion in order to achieve an outcome that is in the public interest, i.e., an outcome that is fair and proportionate, while at the same time reflecting the purposes of the Act. It's obvious from the terms of the guidelines that the Commission takes that view, and it is obviously right that that view should be taken. That enables me, I submit, to place the Commission's case before this court on a fork. There are 2 possibilities. If the Commission is right to treat its discretion as a wide, Mr. Justice Walker type discretion, as it presently does, then there can be no rational basis for treating the discretion which is admittedly conferred on the court by the statute as being a very narrow one. Why not? Because if the Commission is right to treat itself as having a wide discretion, then it cannot be the parliamentary purpose that in almost all cases an impermissibly received donation should be forfeited. And when that definition of the parliamentary purpose leaves the scene, the Commission's case before this court is left without foundation. That's the first tine of the fork. What if, and it may well be that this is the view that the court comes to, what if the Commission is wrong to treat itself as having such a wide discretion? What if the Commission's discretion should be very narrowly defined so that in almost every case involving the receipt of an impermissible donation, a Section 58 application should be made? Well, in that case, given that the Commission's policy recognises, plainly rightly, that somebody must have a wide discretion in order to achieve a proper result that is in the public interest, that wide discretion must be vested in the court because there is no other body that can exercise it. For those reasons, which I hope are logically valid,
I think the second one is circular.
My Lord?
I think the second one's entirely circular. You said that given that the Commission's policy recognises that there must be a wide discretion, but that's the whole issue in the case.
Yes. Well, it's circular in the sense that I take Lordship's point, but I am founding the second limb of my submissions on the Commission's evident perception.
Yes, it may or may not be right. Yes. Mr. Beloff says it's wrong, and it may be wrong.
Well, I suppose what your Lordship is saying is this, that if the case that is being advanced by the Commission before this court and below is a well-founded one, then that case is just simply inconsistent with the policy that the Commission has privately been operating pursuant to these guidelines? Well,
That's entirely right, logically.
that seems to be the logic of the position.
Well, this was drafted in February 2007.
Yes. Yeah. My Lords, bias, very briefly, my friend dealt with it very briefly, I shall respond very briefly. I doubt, with respect, that this will be the last occasion on which Wikipedia will be cited in this court, although it may be the first. The cyber world of the internet is where what would have been in the 18th or 19th century political coffee-housing now takes place, and it is relevant to the context in which your Lordships should consider my bias point. My learned friend then went on to say, well, this is all conspiracy theory, and therefore any grounds for a perception of bias would rest on the paranoid musings of conspiracy theorists, to adopt his term. There is a problem here, practical problem, which is that the judges of this court, for obvious constitutional reasons, are not involved with the hurly-burly of politics on a day-to-day basis, nor these days, for the most part, are those who appear before this court. Is it then right, my learned friend, to dismiss my submissions about bias on the basis that they're just really fanciful inventions from the bar? I submit that it's not, and I'm going to seek to support that submission by one reference in the papers. Could your Lordships go to AB, Appendix 2AB, please? Tab 4. And page 331.
321.
Sorry, Lord, 331.
331, thank you.
Sir Alistair Graham took evidence from politicians and others involved in the political world, and the constitution of his commission obviously was set up to enable expertise to be brought to bear on the position of the Electoral Commission. And it is of assistance to see what is said at 331. The context is a discussion as to who should be allowed to be electoral or election commissioners, and the tension was between allowing people with recent experience of political activity to sit to operate as commissioners, which would obviously be desirable because they would know where the skeletons were to be found and they would know the rules of the game. The tension was between that and the risk of perceived partiality. And that's addressed at the top of page 331 in the two bullet points one sees there. As such, commissioners could act as representatives of their particular party's interests, and collectively such commissioners could seek to influence the commission as a whole in favour of political parties' interests rather than the public interest. Electoral commissions in other countries where the governance structure is overtly political were cited as examples. Second point, decisions on difficult regulatory issues, such as a decision to impose a fine or reference to the DPP or a prosecution, would be tainted with the perception of possible political bias or quid pro quo deals. And then if your Lordships would turn please page 2 pages on to page 333. Foot of the left-hand column on 333, very small numbering, 3-31. The committee does not believe that direct nomination or appointment by political parties of even a minority of commissioners is the appropriate way forward. Such a mechanism might imply that these commissioners would be representatives of that particular party's interests in any commission deliberations or decisions. And it goes on to say there's then a danger of party political deals taking place without due weight being given to the public interest. Now, of course, that recommendation was not followed by the 2009 Act, because there is now a structure allowing for the appointment of commissioners who are, in a sense, representative of individual parties. So that is Parliament's decision, and that one can see the pragmatic reasons for that decision. But the material that I've taken the court to there, I hope demonstrates, by reference to an objective source, that the submissions that I make about bias are not wholly fanciful, but have some substance. Lords, that's bias. Then, looking at the case that was close to the centre of my learned friend's submissions as to a presumption, can I remind your lordships of a short and, we would submit, wholly convincing rejection of that case in the judgment of Mr. Justice Walker. So if we go back to Core Volume Tab 5, page 226, page 226, I think I can pick it up at the foot of the page, paragraph 69. Mr. Justice Walker is here considering, and he's going to reject my learned friend's submission that there is a presumption in favour of forfeiture. Paragraph 69. In my view, the desirability of an effective sanction does not warrant an inference that the court must ask whether the case before it is usual or ordinary. An inquiry of that kind appears to me likely to be of little value, for there are many different factors which may lead to an impermissible donation to be accepted, and ample scope to argue about whether any particular combination of factors is usual or ordinary. We would respectfully ask this court to accept the obvious good sense of that ruling by the learned judge. Then, at paragraph 70, moreover, it seems to me that section 58.2 is very different from the statutory provision under consideration in Chetnik. The presumption in that case protected the citizen. Without it, those paying council tax in error would be deprived of any remedy, and the state would be unjustly enriched at their expense. I do not see any true analogy with section 58.2. Of course, an impermissible donation is something which the party should not have accepted, but we are not concerned here with ensuring that the state is not unjustly enriched at the expense of the citizen. Again, plainly, we submit with respect, plainly right. Chetnik doesn't really help. It certainly doesn't show that there is a presumption to be imported into section 58. This case is quite different. There's no question of the unjust enrichment of the state, but there is the possibility of the potentially unjust deprivation of funds, and the potentially unjust deprivation of the funds that Mr. Bowen has earned in the course of his life, that he'd earmarked for the use of this political party, which he supports, and which he now sees, sitting behind me, he now sees at the moment, subject to your lordships, travelling in the direction of the state's coffers. It's a very, very different context to that considered in the rates case of Chetnik. And then paragraph 71, Mr. Justice Walker then goes on to bring together his thoughts about presumption. I accept that an effective sanction is desirable. In my view, it will be achieved without the need for any presumption if the Magistrates' Court correctly identifies the statutory purposes and seeks to advance them by making an order which is neither disproportionate nor unreasonable, taking account of those matters which the statute requires, and such further potentially relevant matters as the Magistrates' Court considers appropriate. In using that expression, I exclude any such matters as the statute, on its true construction, prohibits the Magistrates' Court from taking into account. In expressing the matter in this way, I seek to do no more than to apply to section 58.2 well-established principles of public law. Again, we will respectfully submit plainly the right approach, and it's certainly been productive of a lot of further litigation that the Commission was dissatisfied with that approach and chose to advance its case as to a much, much narrower discretion, successfully before the Court of Appeal and now before the Lordships. Lords, one very short point on the customs cases, the car seizure cases that my learned friend mentioned briefly and dismissively for perfectly understandable reasons. I accept, he made the point that they arise out of rather different facts, and of course the point is to be made that those cases involve typically the seizure of a car whose value exceeds the value of the goods in question, the smuggled goods in question. I accept that. I accept the analogy is imperfect. But there is some assistance to be drawn from those cases. Can I go, please, to Authorities Volume 2, and the decision of my Lord Phillips in Lindsay, tab 23. My Lord may, although it was a few years ago, my Lord may recall the facts of this case because they were quite striking. Mr. Lindsay was stopped by the customs with really quite astonishing amount of tobacco in his car. And my Lord, at page 1778, my Lord Phillips made an observation about that. Top of page 1778. The cigarettes and tobacco in Mr. Lindsay's car on 23rd July would have kept him and his immediate family going for many months, however hard they puffed. And so there were certainly grounds, in his lordship's view, for this conclusion that the vehicle was being used for commercial smuggling. However, there had been a finding below, which had to be loyally adhered to in the Court of Appeal, that the vehicle was not being used for commercial smuggling and that the goods were being brought into the country for private purposes. That was the basis on which my Lord considered the case, and the passage that we submit is of some help in this context, is at page 1786, paragraphs 63 and 64. Paragraph 63, having regard to these considerations, I would not have been prepared to condemn the Commissioner's policy had it been one that was applied to those who were using their cars for commercial smuggling, giving that phrase the meaning that it naturally bears of smuggling goods in order to sell them at a profit. Those who deliberately use their cars to further fraudulent commercial ventures in the knowledge that if they are caught, their cars will be rendered liable to forfeiture, cannot reasonably be heard to complain if they lose those vehicles. Nor does it seem to me that in such circumstances the value of the car used need be taken into consideration. Those circumstances will normally take the case beyond the threshold where that factor can carry significant weight in the balance. Cases of exceptional hardship must always, of course, be given due consideration. 64. The Commissioner's policy does not, however, draw a distinction between the commercial smuggler and the driver importing goods for social distribution to family or friends in circumstances where there is no attempt to make a profit. Of course, even in such a case, the scale of importation or other circumstances may be such as to justify forfeiture of the car, but where the importation is not for the purpose of making a profit, I consider that the principle of proportionality requires that each case should be considered on its particular facts, which will include the scale of importation, whether it's a first offence, whether there was an attempt at concealment or dissimulation, the value of the vehicle and the degree of hardship that will be caused by forfeiture. There is open to the Commissioners a wide range of lesser sanctions that will enable them to impose a sanction that is proportionate where forfeiture of the vehicle is not justified. The analogy that we would seek to draw from my Lord's analysis there and the present case is this. We would, I think tentatively, provisionally, be inclined to accept that a stringent approach of the type for which my learned friend contends probably could legitimately have been adopted by the legislature, as Lord Neil may have contemplated, in relation to cases of deliberate, knowing contravention of the rules. They would be akin to the commercial smuggling cases where the man brings the tobacco back into the country to make a profit, knowing that if he's caught, he's going to lose the car that he uses on that venture. However, cases of the present type, where the breach was inadvertent, as found, and as plainly it was, and where the primary mischief of the act was not in play because the donation was not foreign, are akin, we say, to the non-commercial smuggling cases that my Lord is considering in paragraph 64, in relation to which it is held that a wide range of potentially relevant factors may come into play and must be taken into account by the court that seeks, as it must, to achieve a proportionate outcome. That's the help that we submit can be drawn from that decision. My Lords, could I then, that's all I want to say in reply to, I think, so I missed a point, yes, that's all I want to say in reply to my learned friend's submissions on the issues as to construction. Can I then come back to the facts of the case? And I'm not, I think, going to, this point in the argument, I'm not going to attempt a complete rebuttal of every point, but I will just seek to give your Lordship a flavour of the way some of these points that are made against my clients might be developed, will in fact be developed, if the matter does have to go back before the district judge. Let me start with the Hayward donation. That is made much of as showing that UKIP had form by the Commission. It's dealt with in the witness statement in bundle, in Appendix Part 2, Sections A and B. Tab 3, witness statement of Mr. Franks of the Commission. I think one can take it from paragraph 25 at page 22. A payment had been made, I think, out of the bank account held by Sir Jack Hayward and his wife, payment of £50,000, and that had been received in early 2001 and had not been returned within 30 days, so had been accepted under the Act. The UKIP, second line of paragraph 25, UKIP had informed the Commission that the donation was a joint donation by Sir Jack Hayward and his wife was in fact on the Electoral Register. A meeting took place. At that meeting, the Commission, Mr. Welford of the Commission, explained to UKIP that there were two options. Half the donations, it was treated as being £25,000 each, so the impermissible donation was a £25,000 donation on the Commission's view. Half the donations could be voluntarily returned to Sir Jack, or the Commission would apply for forfeiture, in which case the money would pass to the Consolidated Fund. UKIP accepted that £25,000 should be paid back. It was paid back. And then if one reads on to paragraph 30, one sees that having been paid back, the return was recorded in the Commission's public records as the return of an impermissible donation for the last quarter of 2001, but the money then came back, it went round in a circle. A further donation, £25,000, was made by Lady Hayward in October 2001, and no objection was taken by the Commission to the money being returned in that way to UKIP. That sequence of events was broadly consistent with the perception that I've been trying to articulate before your Lordships, which is that where the donor, or here one of the two donors, is in fact a permissible donor or a potentially permissible donor, the position that arises where a technically impermissible donation is received is not that serious. The Commission there was rightly raising the matter, but the overall picture was, well, given that the money can eventually lawfully be paid, there's no reason to make a huge fuss about this. There's no reason, for instance, to hasten to bring a forfeiture application and to argue that the money has to be paid to the state, has to be forfeited to the state, even though it is possible to repay it to the donor and then accept a redonation. So the Hayward incident does not have the teeth that my learned friend would like to give it. In any event, the Treasurer then, Mr. Rourke, as the evidence before the district judge showed, left UKIP on bad terms as a result of some sort of internal schism, and did not cooperate, this was the evidence, with UKIP thereafter, and Mr. Smith, the treasurer at the relevant time, did not have access to Mr. de Roque and his records. And in fact, this is a small detail which was forcibly drawn to my attention in the course of today by those who sit behind me. When Mr. Smith asked the Electoral Commission for the records of its dealings with Mr. de Roque, he was told that it wasn't policy to provide those documents, and so he wasn't shown them. These are the small but potentially telling details that are going to emerge if this case has to go back and has to be decided on the law as found by this court by the district judge. That is the Hayward donation. Then one moves on to Mr. Byrne. Mr. Byrne appears on the scene.
I don't object to my friend doing this as long as he doesn't trespass outside the statement of agreed facts. That last suggestion went a little bit beyond paragraph 8.
It may well have done, my lord, and fairness will demand, if this case gets back in front of the district judge, that he should make he should exercise his discretion by reference to all the facts of this case that can be drawn from, as I say, no further cross-examination, but that can be drawn from the documents and from the witness statements. I don't mind my own friend interrupting. I understand the point he makes, but I slightly bridle at the suggestion that we should be fixed with the facts set out in the Statement of Facts and Issues, which were assembled, as we saw it, really for the instruction of this court that was necessary in relation to the points of law that arise, that we should be fixed, completely fixed with those facts and not able to go beyond them in seeking to deal with discretionary matters. There it is. That's 2001. Mr. Byrne, the White Knight, arrives in late 2003. He is on the electoral register. As my Lord Clerk observed, we don't have much information available to us here as to the circumstances in which he made substantial donations in the course of 2004, lawfully, and as to the quantum of those donations, they were substantial. That's clear from the evidence that he, in all, donated in excess of £1 million. My understanding is that they were in the region of £500,000 in the course of that period. They were lawfully made. No criticism is made of UKIP's checking arrangements during that period. That matter does not seem to have been investigated very closely before the district judge, but would be a relevant part of the context against which one has to weigh up what happened in 2005. Then you get to 2005, UKIP makes its returns, as it's statutorily bound to do. It sends its returns, setting out donations to the Commission. They are received by the Commission in the course of late 2004 and early 2005. And what happened then is shown, staying with Mr. Franks' witness statement, is shown at paragraph 34 of the witness statement on page 24. On receipt of each form, RP10, those are the quarterly returns, for the relevant period, so that would have been end of 04, spring 05, and so on, Mr. Duffield searched the electoral register of the local authority area in which the addresses provided by UKIP were located. In respect of the Broadstairs address, the local authority is Thanet District Council. In respect of the Gravesend address, it is Gravesham Borough Council. In both cases, Mr. Byrne was not recorded on the electoral register at the addresses provided for him by UKIP. So, by spring 2005, the electoral register had, as well as carrying out its own checks very properly, had identified that Mr. Byrne, a donor, was not on the register, or did not appear to be on the register, and therefore appeared to be an impermissible donor. That prompted the Commission to send the email, which we have in the same bundle at page 125. email of April the 19th, 2005, from Mr. Duffield of the Commission to Mr. Smith, the UKIP Treasurer. Paragraph, it raises questions about various donors, and this, the evidence below suggested, was a regular feature of dealings between the Commission and UKIP. The Commission would carry out its own inquiries, would raise queries about donors that weren't easily identifiable as registered, properly registered donors. The queries would be investigated, and finally it would emerge that the donors in question were on the register. But the problem, of course, is Mr. Bowen. That's at paragraph 3. Mr. Alan Bowen, we note a single accepted cash donation from Mr. Alan Bowen at a certain address. We notice multiple non-cash donations at a further address. Could you please confirm, clarify various matters? Questions are asked at A, B, and C, which the court will see. Now, I make no particular complaint about this, but Mr. Duffield did not say then, or in the months that followed, we have checked the register, and he's not on it at the addresses you've given to us. That unequivocal statement was not made. It was simply raised as a query. And now I must admit a personal error, because the Statement of Facts and Issues records that there was no response to that email. What it should record is that there was no substantive response to that email. Mr. Smith was not discourteous enough to ignore it altogether. He did respond on the 20th of April, and he said he was looking into it, or would look into it. Of course, it took a long time for that matter to be investigated in 2005, which was an election year, and it would be for the district judge to weigh the significance of the delay in sorting matters out. There then follows, and it won't be, happily, I don't propose to go through it, but there then follows an exchange by email and by letter between the Commission and UKIP, which runs through 2005. Our Lord Mance evidently looked at that in the course of the hearing, and his Lordship observed that the tenor of those communications is pretty amiable, and it is. Mr. Smith, who comes back from his job in the city or in the insurance world, comes back, and in the evenings and the weekends he has to deal with these matters, and he's writing emails to the Commission about this and that, and he's getting friendly communications back. One comes to page 131. We've now got to the autumn of the year. One comes to page 131. The Commission has known for 6 months or so that Mr. Brown is not registered at the addresses given for him. But this is the first occasion on which they actually say to UKIP, you are taking money from somebody who's not registered at the addresses you are giving us. This is a note, an internal note of the Commission's, 24th of October 2005. I called, it's the last entry, I called and spoke to Mr. Smith, and I mentioned that Mr. Bowen has not been on the electoral roll in the last couple of quarters. He stated that Mr. Bowen has been using forwarding addresses lately. Mr. Smith stated that he will email me with Mr. Bowen's registered address. Relatively casual, again I make no complaint, that's just the way the Commission was looking at it. Relatively casual, no written communication at that stage. The first clear-cut communication was later on in December as to Mr. Bowen's non-registration. Matters then proceeded on into 2006. And it became clear that Mr. Bowen was not registered. Still no application to forfeit. Still no hint in 2006 of an intention to forfeit. The general tenor of this, as if Mr. Belloff and I meet in front of the magistrate, I will seek to demonstrate, the general tenor of this is that the Electoral Commission were not that bothered. And UKIP certainly should have done more. We've always accepted that. They should have done more to check, pursuant to the Act. But UKIP were dealing with a situation in which they knew Mr. Bowen intimately. He was easily their biggest donor. They knew exactly who he was. They knew where he lived. They knew what he did. They knew he wasn't a foreign donor. This wasn't a mystery man from Majorca. This was a man who lived in Margate. And they knew that, or they believed rightly, that he had lawfully given many donations in the earlier period. And they assumed, they shouldn't have done, and they wish now they had checked the matter, but they assumed that he remained, as he was telling them, this was the evidence, he remained, and as he believed, he remained on the register. That's how this problem started, and that is why the parties are now here before the Supreme Court. The thing rumbles on through 2006. Still no talk of forfeiture, still no application to forfeit, still no hint of a perception by the Electoral on the part of the Commission that this is a very serious matter which requires the deprivation of wrongful gains. Start of 2007, Sir Alistair Graham's Committee on the Public Standards, Committee on the Standards in Public Life, reports on the Commission's performance and expresses quite forcefully the view that the Commission has not been sufficiently robust in its regulation of matters relating to the funding of political parties. And then the UKIP receive a letter threatening forfeiture proceedings. And from then on, the matter moved through the courts. Well, Lords, certainly there were shortcomings in
What was the
UKIP's
date of the letter threatening forfeiture?
January, my Lord, January 2007, I think, but I will check that.
I mean, that's not the same fact in this series, is it? I don't remember. I certainly haven't noted it.
The date of the application.
It,
Is it in the statement of fact?
no, the date of the application is, my Lord, which was...
Paragraph 14.
Thank you.
The date of the application.
Thank you.
Paragraph 14.
The date of the statement of fact.
Sorry, that tells. Let me have a look at that. That's the application. I know, but I want to know. I mean, this is news about how they were responding to criticism from another body. There's no hint of that in the statement of fact.
Well, no, to be fair, it's not been found, and it certainly would be resisted, I feel sure, by the Commission, that there was a direct connection between the criticism from the committee and the decision to make the application in early 2007.
Where do we see this criticism?
Criticism, my Lord, is in Sir Alistair Graham's report. That's in Appendix 2AB.
Okay.
Page 2...
The letter is on page 180.
281.
Because I've just taken instructions. I mean, it's not only not in effect, we do not accept that we were galvanised into action because of Sir Graham.
No,
we got the letter. Well, that's my own friend suggested as the motive. We have got the letters. The
Letters
letter
are 180.
is at 149, the one my Lord Clark and my Lord Son Brown is seeking.
149.
This is tab 3 of part 2 of the appendix A and B, page 149, letter of the 31st of January. Previous solicitor.
So I was looking at one on page 180, the 9th of January. Was saying that they were minded to apply for forfeiture.
That's the one, my Lord, that I had in mind. I don't think it's 149, I think it is 180.
Sorry, I beg your pardon, 180. Yes, it's a 180, yes, that's right.
But we also see at 167 a letter written on the same date addressing the Treasurer by his first name.
You're quite right, it's the 30th. It should be that one. That was a follow-up. It's 180, 9th of January is the missing date.
Is it going into the brown team? Are you putting this in your brown?
My Lord, Lord Simon Brown asked me for the reference to the criticism. That's at page 281 in the same bundle. Page 281, paragraph 8.1, under the heading Conclusion. Eight lines down, through a combination of deficiencies in its current mandate, that is, too weak in some areas and too broad in others, combined with a lack of courage, competence and leadership in its regulatory and advisory approach, it has not successfully performed these core duties. This has contributed to a loss of confidence, and so on. And then moving on to the last three lines, on the latter, its passive regulatory approach has led to regulatory failure on the issue of loans to political parties, which was the issue of the day.
Well, I mean, unless that report came out before the 9th of January and was digested before the 9th of January, it could not be the explanation as to why the Commission wrote that letter through the closing solicitor, and it's not accepted that it was.
And I don't submit, my lords, that this court could possibly find on the material that I'm able to put before it that was the case. I simply do draw attention for my own purposes to those conclusions, and I draw attention to the fact that it took until January 2007 for the Commission to raise the possibility of forfeiture. There are many more matters, there are genuinely many more matters that I would extract from the documentary material that was placed before the district judge in an attempt to persuade the district judge to exercise his discretion in a way that favoured my client. I simply can't satisfactorily attend to before this court, which is not the tribunal charged with the task of finding facts in this area. I can't discharge that job satisfactorily, and as I've already observed, I can't do so in a very well-informed way, because I don't yet know what this court will hold is the proper construction of Section 58. So, all in all, my lord, for the reasons I've already given, this factual investigation is not open procedurally to the Commission in this court at this stage. But if it is, even if it were, there are many matters that would have to be fully debated, and the subject would have to be the subject of properly informed submissions before the court that exercises the discretion, if this case has to go back to the court below. I hope that this court might feel able to take the indulgent approach that I have indicated would obviously be very gratefully received by my clients, and I don't propose to say anything further about the facts at this point in this litigation. Unless there's anything further I should deal with in reply, those are my submissions.
No, thank you. The court is grateful to counsel for their submissions and will take time to consider its judgment.
Can I just raise one matter, my lord? There is a certain amount of jurisprudence. This is a worst-case scenario on regulatory bodies who bring proceedings, as it were, properly, but are found in the end that the proceedings were not successful. What would your lordships anticipate, as it were, contingent written submissions on costs in relation to that?
That would be the normal course and the appropriate one in this case.
Yeah, I'm very much obliged.
Contingent in advance.
You're not contingent after the judgment.
After the judgment.
After the judgment.
Yes, that's what I understood, your lord.
Factual powers and objective.